Justin Baldoni's lead attorney, Brian Freedman, has been involved in a lawsuit in the LA Superior Court. Now, this was actually Freedman himself being sued, and I'm sure you'll notice the media was very quick and very loud to put out that information when the lawsuit was filed, but they haven't really said much, if anything, about it since. I have been following along with this, and Brian Freedman had filed an anti-SLAPP motion asking to dismiss the claims and also to strike some of it from the record. There was a hearing on that matter, and the judge has now made a ruling. It seems that he won the motion in part, and then some of this stuff can proceed. The judge decided to strike the claims that were based solely on Brian Freedman's speech. There was also the issue that legally they could not bring those claims on behalf of Travis Flores now that he's deceased. But there were a few claims that the anti-SLAPP law did not apply to and are going to proceed because those claims they're like basically regular malpractice claims. So they're not subject to anti-SLAPP protections. I'm going to go over the ruling here, but really quickly, just to give a recap of like what has happened so far. I won't go too much into it. I'll put a link to the videos where I have, gone over this lawsuit previously. But Brian Freedman was being sued by a former client's surviving spouse over statements he made on behalf of Justin Baldoni as in his capacity as Justin Baldoni's attorney in the Blake Lively case. Brian Freedman was previously representing Travis Flores when Travis brought a suit against Justin Baldoni for potential copyright, because he believed that Justin Baldoni's film 5 Feet Apart was kind of copying the work in his screenplay titled 3 Feet Distance. These were both about the cystic fibrosis community. And of course, this all came up when the Lively lawsuit was filed against Justin Baldoni because people used it to criticize him and say ridiculous criticisms along the lines of he stole the life work of a fatally ill man. And Travis Flores did unfortunately pass away, which is why Clement Suri is bringing this on behalf of Travis's estate. But the thing that people would never tell you when they criticized Justin Baldoni over that lawsuit is that it ended with a walkaway settlement. And I won't get into too much of that here because we're not here to talk about that lawsuit, but it ended with no fault, and it did not make sense that Justin Baldoni would have copied things from Travis's screenplay. There was no evidence to support that theory, so there was no way they were going to win that lawsuit, so he was encouraged to, settle and sign a release. Brian Freedman represented Flores in that dispute. That was back in 2021, and Freedman is now Baldoni's lead attorney against Blake Lively. So Freedman, when asked about Baldoni in this context, because of course the media asked him questions about previously representing Baldoni's opponent in that separate action, said that Baldoni and the defendants hadn't really done anything wrong, that he found they were highly ethical people. And Clement argues that these statements imply that Travis Flores was dishonest somehow, or that he brought forth false claims. He said that Freedman took a large retainer for the case up front, then he concluded there was no chance of success, and then he encouraged Travis to settle the lawsuit. Of course, remember, this was years ago. Brian Freedman asked the court to dismiss this lawsuit that Clement had filed. He said that the anti-SLAPP law should apply because it's based largely on Freedman's statements to the media, meaning there's First Amendment protections and also litigation-related protections. And this is not a fully fleshed out description of what the motion said. Like I said, I'll put a link in the comments if you haven't seen it yet. I went over the entire anti-SLAPP motion, but I'm just here to talk about the ruling right now. So let's see. They had a hearing on that. Unfortunately, that was not like a live streamed hearing or anything. I don't even have a transcript of it, but I do have the ruling that the judge made based on the hearing. So let's take a look at what he had to say, what he threw out, and what he decided needed to move forward. Says defendant's special motion to strike is granted in part to the extent described herein. The causes of action for invasion of privacy and defamation are stricken in their entirety under California's anti-SLAPP law. However, the three other causes of action for breach of contract, legal malpractice, and breach of fiduciary duty may proceed in their entirety. So these causes of action, they can move forward. It doesn't mean that the judge is ruling on those causes of action. He's not saying that the plaintiff is correct. He's just saying that the anti-SLAPP law isn't valid grounds for these to be thrown out. They could be thrown out for other reasons later on before this even goes to a trial. It's possible, but based on the anti-SLAPP motion, he's saying these things should still proceed. It says the action is brought by the estate of Travis Michael Flores against Flores' former lawyer Brian Freedman. In 2021 and 2022, Freedman represented Flores, now deceased, in an idea submission and copyright case against Justin Baldoni, a well-known director. In that case, Flores claimed he had originated the idea for a film 5 Feet Apart, created and directed by Baldoni. That case settled as a walkaway, for example, without payment by either side. Now, Freedman, Flores' former lawyer, represents Baldoni in a famous litigation involving Baldoni and the actress Blake Lively. Yeah, I have heard of that one. The lively Baldoni litigation has garnered worldwide attention. Freedman was asked by the press about the older lawsuit in which he represented a client adverse to Baldoni. Freedman responded by saying, "In the copyright infringement case, I learned what great people Justin and Wayfarer were. I learned that they did absolutely nothing wrong and that there was no liability on their part whatsoever. As a result, the case was resolved without any liability on Justin's or Wayfarer or any other defendant's part. This only further confirmed to me that Justin and Wayfarer are exceedingly honorable and highly ethical." So I've said this before, and I know a lot of people have said this is just a cash grab by the defendant. And you know what? Maybe it is. I can't tell you what that person's intentions are. I don't really know anything about Clement Suri, so I'm hesitant to come out and be like, this is a cash grab and criticize him. I look at it like the surviving spouse who may still have some, grief to process. That can take a long time for people, especially when your spouse dies. Like, that's somebody that's very important to you. I leave some room for the possibility that Brian's, statements upset him in relation to that grief, and that maybe he brought forward this lawsuit because of that, and that maybe he really thinks that he has a case. I could understand, as the surviving spouse of Travis Flores, maybe being upset that his lawyer that they paid a bunch of money to is now like saying all these wonderful things in relation to their lawsuit, about their former opponent. So, of course, I know other people have their opinions and we'll see it as a cash grab. I've seen that comment a lot, and I'm not telling people how to feel. I'm just explaining why I don't immediately jump to that conclusion. I think that my thoughts on that are kind of up in the air, So you're not going to really hear me criticize the surviving spouse, even though I think that his case is kind of weak, and I don't think this should have been brought forth. So back to the ruling here, it says, according to the complaint and evidence submitted by Flores' estate, this media statement and similar statements by Freedman to the press brought attention to the Flores earlier lawsuit, damaging the reputation of the late Flores and causing the estate itself to incur legal and other fees to deal with the press attention. Now, the judge is not telling us that they, were damaged. The judge is summarizing the claims made by the plaintiff that damages were caused. So he's not giving his opinion on this. He's summarizing what's been alleged, which I think a lot of people also kind of got mixed up in when it came to the dismissal of a lot of Justin Baldoni's claims against Blake Lively. It's like the judge was summarizing some of what Blake Lively had claimed, or Leslie Sloan, whoever had claimed. And people took the repetition of those statements or the summary of those statements to mean the judge was absolutely saying that was true. And that's not the case. Well, sometimes it is. Sometimes the judge is agreeing, but that's not always what's going on. You have to really look at the context. The complaint brought by Travis's estate here alleges causes of action for breach of contract, legal malpractice, breach of fiduciary duty, invasion of privacy, and defamation. It alleges three general bases for Freedman's liability across the causes of action. First, the estate alleges Freedman committed malpractice, breach of contract, and breach of fiduciary duty in the original representation when Flores was Freedman's existing client. For example, they allege he advised Flores to settle his, allegedly meritorious case for a walkaway. Second, the estate claims that the media statement and similar statements to the press constituted a breach of Freedman's duties as an attorney to Flores as a former client. Most significantly, the estate alleges that the media statement violated Freedman's duties to his former client because it shared confidences about the representation with the press. Third, the estate claims that Freedman committed torts going beyond his duties as an attorney, specifically that he defamed Flores and invaded his privacy by issuing the media statement and similar press statements. And this, since we already talked about the anti-SLAPP motion a lot, I'm going to try not to read this part word for word, but the judge is now summarizing what Freedman said in his motion. It says, Freedman has now brought an anti-SLAPP motion. For the reasons below, the court concludes the anti-SLAPP analysis is different as to each of the three general bases for liability. So first, the judge says that the anti-SLAPP law cannot apply with some of these claims because the claims are regarding Freedman's actions when Flores was Freedman's existing client. So nothing to do with the media statements that he's made now as Justin's lawyer, but some of these claims are related to what he did when he was Travis's attorney. Second, he says the malpractice, breach of contract, and breach of fiduciary duty claims, that if they're based on his media statements, then the anti-SLAPP law does apply at first, but the court's saying that the media statement on his face, it could reasonably be construed to violate fiduciary duty to the client, like his duties of loyalty and confidentiality. And because the statement there is not protected by any other legal privilege, the estate has shown enough evidence that the claims could be valid, so they can move forward. So basically, the first step of California anti-SLAPP is satisfied there. Is the claim based on protected speech or petitioning activity. So Brian Freedman satisfies the anti-SLAPP law with that on the first step. But on the second step, does the plaintiff's claim have at least minimal merit? That's where Brian Freedman's anti-SLAPP motion fails in regards to these three. The estate showed enough evidence that the statements might violate the attorney's duties, and therefore they're allowed to continue. It says third, the claims for defamation and invasion of privacy cannot go forward at all. So these are the ones that are being thrown out. Those claims are entirely based on the media statement and similar statements to the press. They are thus obviously subject to anti-SLAPP law in their entirety. They also certainly lack merit in their entirety. Since Flores is deceased, his estate cannot bring a defamation or invasion of privacy cause of action on Flores' behalf. The court further explains its reasoning below. In a ruling on a defendant's special motion to strike, the trial court uses a summary judgment-like procedure at an early stage of the litigation. This is a two-step process. First, the moving defendant has the burden of establishing that the lawsuit's claims are based on activity protected by the statute. And the legal standard here is kind of what I was just talking about with the two steps of the anti-SLAPP. So I'm not going to read this part right here. I feel like we don't really have much else we need to say about that. Moving down to the factual history, the judge writes, the decedent, whose estate brought this action, Travis Michael Flores, was a published writer born with cystic fibrosis. In 2012, he developed a screenplay titled 3 Feet Distance, based on his own experience living with his condition. Flores participated in a television series entitled My Last Days in or around 2016, hosted by executive producer Justin Baldoni. During his tenure on the series, Flores allegedly shared his ideas for 3 Feet Distance with Baldoni. Baldoni then went on to direct 5 Feet Apart, a 2019 motion picture officially inspired by the life of CF activist Claire Wineland, who was also cast on My Last Days. The estate alleges that Baldoni stole Flores' script to develop 5 Feet Apart. In July of 2021, Flores retained Freedman and the other defendants to pursue a federal copyright infringement action against Baldoni for stealing the script to 3 Feet Distance. Freedman allegedly filed the action without performing due diligence to investigate the strength of Flores' claim and failed to uncover key evidence supporting Flores' position. Instead, Freedman allegedly concluded Flores' case was meritless upon Baldoni's filing of a motion to dismiss under Federal Rule of Civil Procedure 12b-6. Instead, Freedman allegedly concluded Flores' case was meritless upon Baldoni's filing of a motion to dismiss. Flores entered into a non-confidential settlement of the copyright action, ending the case with no admission of liability or lack thereof, and a waiver of any party's right to recover fees or costs, so it was a walkaway. The copyright action was dismissed on March 29, 2022. Flores passed away on May 23, 2024. In December of that year, Freedman began representing Baldoni in his high-profile litigation against actress Blake Lively. The parties agree that the factual and legal claims asserted in the Lively-Baldoni litigation are unrelated to this action. However, in January of 2025, Freedman made the media statement references above. The estate contends that defendants, that's Freedman and his firm, breached their contractual, fiduciary, and professional obligations by performing insufficient work, providing poor legal counsel, and advising Flores to agree to the settlement, failing to disclose a conflict of interest, and failing to maintain and return a complete client file. And again, the judge is recapping basically what the claims are here. That he's not saying that's what he found. This has not gone to trial or anything like that. This was a hearing just on the anti-SLAPP motion. I probably will go over some of this lawsuit, the Flores lawsuit, just to talk about some of the factual stuff, because if you read the lawsuit, it becomes pretty clear why Travis was encouraged to do a walkaway settlement, but that's kind of beyond the scope of what I'm looking at right now, so I'm not going to worry about that at the moment. All right, back to the ruling here. It says, Suri, that's Clement, the surviving spouse, also contends that Freedman's public statements constituted disclosure of confidential attorney-client communications that undermined Flores' legal position, invaded his privacy, and defamed his character. At the first anti-SLAPP step, the question is whether a defendant has met the burden of showing that a plaintiff's claim arises from protected activity, which happens when that protected activity underlies or forms the basis for the claim. And then he notes here that in analyzing whether a claim arises from protected activity, the court is not bound by the labels given to a single cause of action. So if a claim for relief is supported by allegations that concern both protected and unprotected activity, the court has to distinguish between the allegations supporting protected and unprotected activity and apply the anti-SLAPP law only to the allegations of protected activity. Okay, so I'm trying to simplify that. The court looks at the specific actions behind a claim. So it doesn't just look at the title of the claim. So for the claim, like breach of fiduciary duty is the title of the claim. But within the claim, the actions behind the claim could be a couple of different things. So we have 1, giving bad legal advice when Travis was the client, and then 2, statements to the press. And they're saying that if some parts of the claim involve protected activity and some do not, the anti-SLAPP law only applies to the parts of the claims with the protected activity. So in this case, only the speech-related parts. So for breach of fiduciary duty, which is one of the claims that is being allowed to move forward, sure, the anti-SLAPP law would apply to like the speech-related things within that claim, but it doesn't apply to giving allegedly bad legal advice while Travis was the client. Hopefully I made sense. Sometimes I scrambled egg brain when I try to explain things. So the court here is beginning their anti-SLAPP analysis. They're looking at Flores as a then current client. So we're looking at activity from Brian when Travis was the client. It says here, much of the complaint falls squarely within the rule barring use of the anti-SLAPP law to strike ordinary malpractice claims. The complaint alleges inadequate investigation by Freedman in Flores' former action and advising Flores to accept an allegedly inadequate settlement in his idea submission case. There's no basis for applying the anti-SLAPP law to these allegations, which provide the primary bases for the malpractice, fiduciary duty, and breach of contract claims. Indeed, Freedman does not argue to the contrary. While his initial motion is somewhat unclear on this point, Freedman's reply brief makes clear that he does not seek to strike allegations related to Freedman's conduct while he represented Flores as a client. Accordingly, there can be no dispute that the malpractice, fiduciary duty, and breach of contract allegations fully survive the anti-SLAPP motion to the extent that they are premised on Freedman's activities while Flores was a current client. So that doesn't have anything to do with speech. It doesn't have anything to do with his media statements, his protected speech. It has to do with the advice he gave Travis when he was his client. And there's not a protected speech basis to throw this out. It has nothing to do with the Lively lawsuit or any comments he's made. Those parts of the lawsuit are about what Brian did as their attorney. Now, Brian can certainly fight that and say, no, the advice I gave you was good advice. And I wouldn't be surprised if we end up seeing that. But an anti-SLAPP motion is not going to be the proper way to get those claims dismissed. Freedman also argues that actions he took on behalf of Baldoni when Flores was a former client are not categorically exempt from the anti-SLAPP law. Here, Freedman finds legal support. The case law has distinguished for anti-SLAPP purposes between a client suing his or her former attorney for actions taken on the client's behalf and a client suing his or her former attorney for actions taken on behalf of another client. And I'm probably going to skim over the case law stuff here. I'm not really trying to get that far into the weeds. Freedman points to the following allegations as undertaken when Flores was a former client and thus subject to the anti-SLAPP law. A, failing to maintain and return a complete client file. B, failing to disclose a conflict of interest when Freedman began representing Baldoni. And C, Freedman's commenting on Flores' action and Baldoni's character to the press via the media statement. The court agrees in part and disagrees in part. The first two categories, failing to maintain and return a client file and failing to inform Flores of the conflict, are not actions Freedman took solely on behalf of different clients. Rather, these are allegations about obligations that Freedman owed directly to Flores and failed to perform on Flores' behalf. These are thus activities that could give rise to an ordinary action for legal malpractice. They are therefore categorically outside the protections of the anti-SLAPP law. Indeed, contrary to Freedman's argument, the only case to address the issue specifically finds that a failure to properly return a client file to a client is an act of legal malpractice, categorically falling outside the anti-SLAPP law. So I need to look into this part about failing to maintain and return the client file. I don't know what the claims are about that. The thing that sucks is with LA Superior Court, I would have to buy the documents filed by Clement's side to look at that. So I'll probably do it. I just, I didn't want to purchase anything that I didn't have to, buy to do this video. So I guess I will buy and look at it, but I'm going to talk about that in a separate video because I don't want to pause, derail what I'm doing, and then come back. So we're just going to finish this, and then I will discuss that part of the lawsuit separately. Anyways, the judge is saying that these accusations, the claims, they're categorically outside the protections of the anti-SLAPP law, which makes sense because what does that have to do with protected speech? You know what I mean? Also, this part here, failing to inform Flores of the conflict, Flores unfortunately passed away like 7 months before there was a lawsuit. 7 months before Blake Lively brought her lawsuit. I don't know how many months before Brian Freedman was ever even contacted by Baldoni and the Wayfair parties, but does he have to inform the estate? I don't know. That's a little confusing to me, so I'm not going to get into the weeds there at the moment. I don't want to say the wrong thing. You know what I mean? So let me keep just reading what the judge had to say here. The allegations concerning client files and a disclosure to Flores about a conflict of interest are not protected by the anti-SLAPP law, and Freedman has not satisfied his burden at the first anti-SLAPP phase as to those allegations. So these are the three that are moving forward: the malpractice, breach of duty, breach of contract. That leaves the media statement and similar press statements. These statements plainly were not made on Flores' behalf or during Freedman's representation of Flores. Rather, they were made on behalf of a subsequent client, Baldoni, during Freedman's representation of Baldoni. The media statement and similar statements are therefore not categorically outside the anti-SLAPP law. And since the media statement and similar statements are not categorically outside the anti-SLAPP law, they are clearly and obviously protected by the anti-SLAPP law. These are statements made to the media on a matter of intense public interest. As a long line of California case law recognizes, issues involving celebrities, like the Baldoni lively litigation, are topics of widespread public discussion and therefore may be an issue of public interest. Moreover, the media statement and similar statements clearly contributed directly to that discussion. In making the media statement and similar statements, Freedman facially participated in or furthered the discourse that makes an issue one of public interest. The statements were, therefore, under governing California law, statements concerning matters of public interest protected by the anti-SLAPP law. In sum, the court concludes that Freedman has shown that the complaint's allegations concerning the media statement and similar press statements, and only those allegations, fall within the anti-SLAPP law. The court turns to the second anti-SLAPP step as to those allegations only. So here's where the estate has to show that their allegation has some merit. So that means they have to have some evidence supporting that they could win this claim. So the court isn't actually weighing the evidence. They're just assuming the evidence is true in order to make this determination. So the plaintiff Clement's evidence is assumed to be true. And then they check whether the defendant's evidence, Brian Freedman's evidence, defeats the claim as a matter of law. So the plaintiff only has to show that the claim is legally valid and could possibly succeed at trial. Here, the estate has the burden of showing a triable issue of fact as to whether the media statement and similar statements can be a basis for the breach of contract, legal malpractice, fiduciary duty, invasion of privacy, and defamation claims. The court distinguishes between the different causes of action. It concludes that for the attorney-client related causes of actions, the one we just talked about, there is a showing of minimal merit, so those are the three that are moving forward. For the defamation and invasion of privacy causes of action, there is not. Since the media statement is the only factual basis alleged for the defamation and invasion of privacy causes of action, and since those claims are clearly without merit, those two causes of action are slappable in their entirety. Slappable. So here he's talking about legal malpractice, breach of fiduciary duty, and breach of contract. It says Freedman argues the media statement cannot be a basis for these claims for three main reasons. One, it's protected by fair report privilege. Two, it's protected by litigation privilege. And three, the media statement did not breach his fiduciary, legal, or contractual obligations to his former client because it did not reveal a client confidence. So nothing confidential was exposed. In the court's view, each of these arguments fail. First, on the record here, whether the true and fair report privilege applies is a question of fact for the jury. Here, there is ample question as to whether the report was in fact true and fair. Unlike cases in which the true and fair privilege was found by courts to apply as a matter of law, the media statement does not merely recite the facts of an underlying legal proceeding, nor does it present basic facts of a legal proceeding with some literary license or mild puffery. Rather, it makes affirmative statements about the merits of both Flores' idea submission case and the character of Baldoni. It claims that Baldoni and his associates were great people, that they did absolutely nothing wrong in connection with the facts that led to the underlying action, that there was no liability whatsoever for Baldoni, and that Baldoni was exceedingly honorable and highly ethical. All of this is in dispute. So the court says there is some doubt about whether it was a true and fair report because it goes beyond just describing what happened in the lawsuit. So it's not a neutral summary. It goes further and gives opinions about Baldoni and his character. Since it's making strong claims about the merits of the case and the people involved, the court can't say the statement was simply a neutral summary of the legal proceedings. The estate has introduced a declaration from Melissa Yeager, who has knowledge of the facts leading to the underlying disputes and who strongly disputes Baldoni's integrity and character in connection with the film that gave rise to the original litigation. It has introduced another declaration from Clement Suri, indicating that Freedman did not interview the key witness in the underlying litigation and that Freedman failed to consider critical evidence as to liability. While this evidence is certainly subject to dispute and may or may not ultimately be credited by a jury, so important to say there, the judge is rehashing what's going on here, but this is something that would ultimately have to be, probably shown to a jury. It is more than enough to establish at least a triable issue as to whether the statements made by Freedman and the media statement were true and fair. Accordingly, the true and fair privilege is not enough for Freedman to prevail at the second anti-SLAPP step. So Melissa Yeager is Claire Wineland's mother. Claire Wineland, who was some of the inspiration behind Justin's project. Unfortunately, Claire has passed. She can't speak for herself here. But they seem to have a really good relationship. In fact, here's a post of Melissa saying, "Oh man, such a beautiful and heartwarming post from Justin Baldoni. Feels like just yesterday. Some days, this picture and Claire's surprise talk at Life is Beautiful Festival. That talk is probably one of my favorites of hers. And I lean into the wisdom she shared. Still, look at everything you have in front of you, the good and the bad, and make something beautiful with it. I'm trying, my love. Miss and cherish you every second of every day. Thank you for all the joy. Thank you, Justin, for your friendship and your commitment to Claire and the CF community. You're making quite an impact." And this was May 2024 that Melissa's mother posted this photo with this caption. Keep that in mind. Here was back in 2018, unfortunately, when Claire passed, but it says, "This is everything. Her smile, her light, and the amount of gratitude that filled her almost every day is incredible. I hope she's reveling in this post by her hero, Bernie Sanders. Thank you, Justin Baldoni, for giving her this opportunity while filming." And the reason I show you those posts by Claire's mother is because this does not align with what's written in her declaration. So Claire Wineland was a paid consultant on this movie, and Melissa Yeager, her mother, has now put out a declaration for the plaintiff, Clement Suri, and the estate of Travis Flores, basically allowing them to call into question the characterization of Justin Baldoni's character and integrity in connection with the film that was related to the original lawsuit. And in this declaration, which I'm not going to read all of right now, because when I go over the actual lawsuit, that's when I'll go over some of these exhibits and stuff, but I just want to focus on the ruling here. Right now, I have to briefly explain so I can show you why the judge ruled the way he did. But she says, "Based on my experiences and observations, and based on what Claire communicated to me, I formed the perception that Mr. Baldoni benefited publicly from association with sick or vulnerable individuals, including by using those associations to promote himself and or projects." And she's criticizing the project and the way that it was, I guess, marketed, and saying that Claire had raised concerns to her, which again, not in line with this from May 2024. "Thank you, Justin, for your friendship and your commitment to Claire and the CF community. You are making quite an impact." And in the interest of staying on topic for the ruling, I'm not going to unpack that too much right now. I will later, like I said, but that is highly suspect to me. She seemed to be quite friendly with Justin and quite pleased with Justin, and then all of a sudden she has all these concerns, and Claire cannot speak for herself. I don't know what's going on here. Maybe her mother really doesn't like him. Maybe she really felt that way, but she certainly made it seem the opposite as recently as less than 2 years ago. So that's a little confusing. And whether or not, she's being truthful, if this were to proceed to trial, that's certainly going to be called into question. I'm not going to sit here and bash her and say awful things. I don't think that's productive. I'm just saying, I'm not sure how useful that declaration is going to be, because it took me all of 3 seconds to find a post that she made praising him within the last year and a half, maybe a couple years. I didn't look very hard. So something's not adding up. Anyways, back to what we came here for. Second, the litigation privilege does not apply to the media statement either. That privilege does not protect media statements such as this one. The privilege simply does not apply to press conferences and press releases, of which the media statement was one. Third, contrary to Freedman's argument, there is a triable issue of fact as to whether the media statement violated his professional obligation to not disclose client confidences. Freedman argues that the statement cannot have disclosed any client confidences, since the media statement refers only to Baldoni's character and information he learned from Baldoni, not to information he received from Flores. There's a significant problem with this argument. It misunderstands Freedman's professional obligations and the meaning of an attorney's disclosure of confidential information under the law. The relation of an attorney and client is one of the highest confidence, and as to professional information gained while this relation exists, the attorney's lips are forever sealed, and this is true notwithstanding his subsequent discharge by his client. Confidential information for these purposes is far broader than matter protected by the attorney-client privilege. It is also broader than matter that is, in an ordinary language sense, confidential. Although the attorney's duty is to refrain from disclosing a client's secrets, the word secret in this context has a very broad application and refers to any information gained in the professional relationship that the client has requested to be held inviolate, or of the disclosure of which would it be embarrassing or likely detrimental to the client. Critically, the duty of confidentiality a lawyer holds to a former client extends even to disclosing material obtained from someone other than the client. The duty applies to all information relating to client representation, whatever its source. Indeed, it extends even matters of public record that have been communicated to the attorney in confidence and that might cause the client or former client public embarrassment. So maybe they do have a good case for that. No, I'm not an attorney. They at least have a good enough case for it to move forward. Thus, in the broad sense that California law forbids attorneys from disclosing client confidences, the media statement appears on its face to violate a client confidence. It certainly appears that in the media statement, Freedman was disclosing confidential information learned in a client representation to the detriment of a former client. Such disclosure would appear to violate the purpose of the California rules protecting client confidentiality. That purpose is, in part, to protect the attorney-client relationship by giving clients confidence that attorneys will not use information gained in the litigation for their personal gain once representation is terminated. The estate has also put in evidence of damage arising from the media statement, including costs expended to respond to the media interest in the older lawsuit. At a minimum, therefore, there is a triable issue of fact as to whether the media statement violated Freedman's contractual, fiduciary, and legal obligations as an attorney. Fourth, while Freedman raises the argument, he cites to no cases establishing that the foregoing limitations of disclosure, which impose stricter professional obligations on attorneys than the limitations that apply to ordinary citizens under the First Amendment, would not apply merely because the media statement might not constitute actionable defamation under ordinary, on the record here, First Amendment standards. To the contrary, the law is clear that a lawyer's right to freedom of expression is modified by the lawyer's duties to clients. Okay, I'm reading this judgment and I keep applying it to this other case that I'm covering right now, where the lawyer's done some absolutely crazy shit, and it has nothing to do with this, but I want to read this case now. This is defamation and invasion of privacy. By contrast, the defamation and invasion of privacy claims lack merit entirely. Deceased persons and their estates do not have a cause of action for defamation, nor do they have claims for invasion of privacy. That claim as well dies with the person and cannot be asserted by an estate. Here, the only basis for a claim of defamation or invasion of privacy is that Flores was defamed and had his privacy invaded by the media statement. Although the estate's administrator, Clement Suri, has also brought the action under his own name, there is no allegation that the media statement or similar press statements defamed Suri individually or invaded Suri's own privacy, nor does it appear it could be. There's also no basis alleged for the defamation and invasion of privacy claims beyond the media statement and similar statements in the press. These two causes of action, therefore, are entirely subject to the anti-SLAPP law under anti-SLAPP prong 1. They entirely lack even minimal merit under anti-SLAPP prong 2. Accordingly, these two causes of action fail completely. So the judge says that these two causes of action are to be stricken. The three other causes of action may proceed. And then as far as like the attorney's fees and costs that Brian Freedman asked for, it says if Brian seeks an award of fees and costs in connection with this motion, that award must be limited only to the success obtained on the motion. For example, fees and costs incurred regarding briefing on the defamation and invasion of privacy causes of action. And then the judge made a note here at the bottom. It says the court also notes in passing that the anti-SLAPP law also would not prevent using Freedman's actions after he ceased representing Flores as evidence of malpractice committed while Flores was a then current client. For example, if Flores' theory of the case were that Freedman failed to adequately represent Flores at the time Flores was a client because he hoped to gain future business from Baldoni, the media statement could be introduced as evidence in support of that claim without triggering even the first prong of the anti-SLAPP law, so long as the media statement did not form the basis of a malpractice claim. They would have to use that to prove that Brian basically gave bad advice to Travis because he wanted Justin to be a future client. I would be really surprised if that was the case. All right, guys, like I said, there's a lot of stuff in that case, especially some of the plaintiff's motions that I want to go over, but I don't want to do all that right now. I want to keep that just to the ruling. So I'll be back later, I don't know when, to talk about that. Thanks for watching. Don't forget to hit the like button for me. That helps me out a lot. And I'll see you all soon. Bye.